Ms. Kathryn Piscitelli, got it. That's
Yes.
a New Jersey name. Is a labor and employment lawyer with the firm of Egan Lev Siwica in Orlando, Florida. Ms. Piscitelli is also a member of the Florida chapter of the National Employment Lawyers Association, and she served as chair of the National NELA's USERA, meaning the Soldiers and Sailors Relief Act, task force in 2004. Ms. Piscitelli has spoken on numerous occasions about USERA and fair employment practices. She earned her BS from Northern Illinois University in 1975, and another Duquesne lawyer earned her JD from Duquesne University in 1983. This is the day of the Iron Dukes on the panel, I guess, today.
Good afternoon. I'm Kathryn Piscitelli from Orlando, Florida. My remarks today will focus on several issues that I urge the subcommittee to look at to improve USERA's protection of our service members in civilian employment. 1, mandatory arbitration. 2, disparate impact. 3, federal funding as a hook to override state sovereign immunity. 4, wage discrimination. And 5, protection of potential applicants for military service. I know that during this hearing you're also taking testimony on the huge problem of employers imposing mandatory arbitration as a condition of employment. Mandatory arbitration is also a major problem for returning service members under USERA. However, the Civil Rights Act of 2008, H.R. 5129, of which you are an original co-sponsor, Chairman Andrews, would solve the mandatory arbitration problem under USERA. I very much appreciate your leadership in co-sponsorship of H.R. 5129, and I urge Congress to pass it as soon as possible. H.R. 5129 also would improve protection of service members under USERA in another significant way by providing a federal funding hook to trump states' 11th Amendment immunity from private suits for monetary relief. USERA makes available to state employees the same monetary remedies as it does for private and local government employees. Yet in the wake of Supreme Court decisions narrowing the circumstances under which federal laws can effectively override state immunity, it has become virtually impossible for individuals to bring private actions against state employers under USERA. The way out of this conundrum is to amend USERA to condition states' receipt of federal funding on their waiver of 11th Amendment immunity. That is precisely what H.R. 5129 would do. Again, thank you, Chairman Andrews, for your co-sponsorship of this crucial legislation. USERA's prohibition on military-related discrimination would be strengthened by amending USERA to clarify that the Act protects through Section 4311A against employment policies and practices that on their face are non-discriminatory but have a disparate impact on service members. Although other statutes expressly provide for disparate impact claims, USERA does not. As a result, there is judicial uncertainty as to whether disparate impact claims are available under USERA. Amending the statute would remove the cloud of doubt and thereby ensure that service members who are harmed by facially neutral policies and practices have a remedy under USERA. Removing or redrafting the exemption of wages or salary for work performed from the definition of benefit of employment at Section 4303, subsection 2 of USERA is warranted as well. The exemption evidently was included to clarify that USERA does not require payment of wages or salary to employees when they are away for military service and thus not performing work for their employers. But the exemption is ambiguous and as a result can, and in fact has been, misconstrued as authorizing pay discrimination against service members. This is surely not an outcome that Congress intended when it enacted USERA. In addition, I recommend amending Section 4311A to explicitly prohibit discrimination against potential applicants for membership in a uniformed service. In enacting USERA, Congress clearly intended that potential applicants for the service would fall within the ambit of the Act's ban on service-related discrimination. However, there is no express provision to this effect in the statute. In the absence of express protection for such persons, there is a risk that employers will deter employees from joining the military and that courts will do nothing to stop them. In conclusion, protection of our service members in civilian employment will be improved if mandatory arbitration is abolished and USERRA is amended by providing for disparate impact claims, adding a federal funding hook to override state immunity, clarifying the wage exemption from the benefit of employment definition, and explicitly prohibiting discrimination against potential applicants for military service. It's great that Congress is looking into these issues. I appreciate the opportunity to testify today.